Hello, my name is Michael Massman. I'm an attorney with Neighborhood Legal Services of Los Angeles County. This presentation is titled To Answer or Not to Answer, and it is meant to help people facing a credit card lawsuit make an informed decision about whether or not they should answer that lawsuit. The presentation is meant to provide information only. It is not legal advice. If you need legal advice, you should consult an attorney on the specifics of your own individual case. So if you are being sued for a credit card debt, the first thing you need to understand about answering is how much time you have to make that decision. Generally, you're going to have 30 calendar days from the date you were served in order to determine whether or not you want to answer. This deadline can vary. If you were served personally, that is, if you were handed the documents in person, the summons and complaint discussed in the earlier presentation, then you have 30 calendar days. If, on the other hand, you were not handed the documents personally, but rather they were left at your home with someone and mailed to you, then you have 40 calendar days from the date that they were mailed. Importantly, calendar days means weekends or holidays. So it's important to know this deadline because if you miss it, the other side, the plaintiff that sued you, can go directly to the court and ask for what's called a default judgment, which is a judgment they get when the defendant has not answered in time. So deadlines are important. You can ask for an extension. There are sort of specific ways to do that. If you have questions about that, you're welcome to reach out to us. So sometimes people decide not to answer, and that can be a valid approach. If you don't answer, you certainly will lose. But you don't also have to go through the trouble of defending yourself and the stress of trial, dealing with other deadlines, because it's not just the answer deadline that will come up in the case. And there may be circumstances in which you want to do that. So we're going to talk about those, but first let me just give you an overview of the sort of three main steps in a trial like this. So first, there's the pleading stage. That's when the other side puts in a complaint and they say so-and-so owes us a certain amount of money for such and such reason. And then the defendant, if they want to answer, would put in an answer, filing that with the court and sending it to the attorneys for the party suing them. And what goes in an answer is legal reasons they do not owe the money. At the end of the process, jumping ahead here, is a trial where the judge makes a final determination as to whether or not the money is owed. And in between that is what's called discovery. Trials are not like they're often depicted on TV. They're not supposed to be surprise moments where people aren't informed. The purpose of discovery is so that the parties can exchange information and documents with each other so that everybody's informed, so that when a trial happens, the judge can make a decision based on the evidence as opposed to surprise tactics. So those are the three main steps in a trial and the three main things you'll almost certainly have to deal with. There can be other elements too, depending on what happens, but those are the three main ones. So important things to consider before answering. What will happen if I lose? I think it's always a good idea to consider the worst case scenario. If one loses, can one protect their income? Maybe I don't even want to answer at all because all of my income is exempt. And we'll talk about what exempt income is on the upcoming slides. Do I have a legal defense? What is a legal defense? Like, essentially, can I convince the judge? Do I have a reason that I don't owe this money? And that's not, I lost my job, as sympathetic as that might be. A legal defense is a legal reason, such as identity theft, that you do not owe the money. If you do recognize the debt or you don't want to deal with a lawsuit, then negotiating a settlement is an option. So that's something you can do instead of going to court. And then if you do want to go to court, you're going to have to consider whether or not you have the time and capacity to represent yourself at trial. So again, these presentations are meant to provide some information so you can make a more informed decision about all of that. So with that in mind, let's talk about exempt income. Social Security, for example, is exempt. That means that if the credit card company gets a judgment against you for thousands of dollars, it doesn't matter. They can't touch your Social Security income. If you somehow manage to accumulate a great deal of it, that there might be an exception, but as a general rule, Social Security income is exempt from collection. Most retirement accounts are exempt from collection. Money that you make that is less than the minimum wage based on a 40-hour work week is also exempt from collection. And money in your bank accounts less than a certain amount. Currently, we're in February of 2025, and the amount of money protected in your bank accounts, plural, in California is $2,180. That number adjusts annually, and right now it is $2,180. So if you have less than that amount in your bank accounts, the creditor, even with a judgment, shouldn't be able to take that money. Knowing this ahead of time makes you can help you to consider whether or not it's worth answering, because if they can't get anything from you, then and you don't have a legal defense, then you might want to think about whether or not it's worth answering. So something to keep in mind if you do that, and for that matter, even if you do fight the lawsuit and lose, is that if they have a judgment against you, it's going to stick around for a little bit. It's going to stick around for 10 years, a smaller amount of money. And they're going to be able to renew it one time for 5 years. It's going to collect interest during that time. And any time when they have a judgment against you, they can attempt to collect by either trying to levy your bank account or garnish your wages. They can also put a lien on your home, but this is concerned more with the levies and the garnishment. So you can file what's called a claim of exemption if indeed they try to take wages from you or touch your bank account. You're absolutely encouraged to reach out to Neighborhood Legal Services if this happens, if you've lost a lawsuit and you get notification or find that money's been removed from your bank account. The same goes for if somebody's recorded a lien on your property. We can talk to you about that as well. But I put this here so that you can understand that even if you lose the lawsuit, there's still ways to protect your wages and assets. And you're, again, welcome to reach out to us to talk about that. So common legal defenses, again, like if you're going to go through the trouble of putting in an answer and going through discovery and defending yourself at trial, then you're going to want to know that you have a legal defense, because you can't win without one. So these are some examples of legal defenses. Identity theft, somebody stole your identity. A mistake, you're not the wrong person, you're not the same Joe Smith or whatever. Statute of limitations, they waited too long to sue you. Here in California, they have 4 years to sue you on a breach of contract claim, which is what a credit card lawsuit is. So 4 years from the date that your payment became due and you missed it to sue you. So that might be one. Lack of legal capacity. Maybe you were a minor, for example, when you incurred the debt. That might be a defense as well. So these are some common legal defenses. Another really important legal defense to understand that you may not be as aware of is what's called standing and privity. So those are both legal terms. You can think of privity as a relationship. If you have a contract with somebody, you're in what's called privity of contract with them. Similarly, if you own a home with somebody, you're in privity of estate. So privity is a sort of legal relationship that's recognized. And standing is an injury. An injury that is recognized by the court is something they can do something about. So if you're being sued by a third-party debt buyer, that is somebody who bought this debt from the original credit card company, you're probably going to have a privity, or you're definitely going to have a privity standing defense. And it goes a little bit sort of like this, that I didn't sign a contract with these people, therefore I don't have a contractual relationship with them, and for that reason they're not injured. And so that's a defense. And in the next presentation, when we talk about filling out the forms, we'll show you how to assert that. But just be aware that if you're being sued by a third-party debt buyer, this is a defense that's got some technical legal jargon in it that you may not be aware of. So what are not defenses? Life has been hard. Inability to pay. If you're dealing with an illness like COVID-19, or you lost your job, or you really want to pay, these are all very sympathetic and admirable in some circumstances, but they're not legal defenses, and a judge can only make a determination based on a legal defense. You're going to want to understand, as I've sort of talked about a little bit, what it means to represent yourself. That means you got to answer the complaint. That means if they send you discovery requests, you're going to need to respond to those, and those can come in a few different forms. That means that you're going to need to respond to motions. Motions are arguments that the other side might make to the court before a trial. And if you do go to trial, of course, you're going to need to defend yourself at trial. And for that matter, all along the process, you might be able to reach an agreement. And so you want to consider your ability to negotiate an agreement as well. So we're available to talk to you about any of those issues if you'd like to reach out to us. This is our website. On our website, we have a self-help questionnaire. If you take the time to fill that out, that'll begin the process, and either one of our paralegals or intake screeners will reach out to you about the next steps. Thank you very much for your time and attention.